Siúd Bratimachta in Ulster Cahir Valia Áha Clia. Good afternoon, everyone, and welcome to this event of the Brexit Institute of Dublin City University. My name is Niall Moran. I am the Deputy Director of the Brexit Institute, as well as an Assistant Professor in Economic Law at the School of Law and Government in DCU. It's my great pleasure to open this event on the future of UK and EU migration law after Brexit. I think this is a very timely moment for this event in light of a myriad of recent developments in the area of migration of great relevance to EU-UK relations. It's also great to see the level of interest in this topic. We've had over 120 signed up for this event, last I checked. And I would also just remind people that the event will be recorded today. So the areas range from EU reform efforts on asylum and migration against a backdrop of crisis in the Mediterranean to the pending UK Supreme Court appeal on the UK-Rwanda relocation agreement, as well as a general trend towards the offshoring of asylum claims, not just in the UK, but also in several EU countries. I look forward to hearing the contributions of our panel on these challenging questions and other areas they may wish to touch upon. I want to also say that we're very lucky today to have David Davenpower with us as chair for this event. David, of course, needs no introduction to those who've watched the news in Ireland in recent decades. David was the long-standing RTE political correspondent, as well as being the former Northern Ireland editor for RTE News. One of David's works that I'd really recommend watching is his 2015 documentary, Gallipoli, Ireland's Forgotten Heroes. It's an excellent account of another highly significant episode that took place in the Mediterranean. Gallipoli involved the loss of life of thousands of Irish soldiers during the First World War, battle in which David's grandfather served. And I'd also say that it left a significant mark on Ireland. So it is my honour now to introduce our panellists, who will be fully introduced by David before their talks. Firstly, we will have a keynote speech from Sir Simon Hughes, former UK Minister and Deputy Leader of the Liberal Democrats. This will be followed by talks and a panel discussion with Mathilde Ventrella of Liverpool John Moores University, Hilke Becker, Chairperson of the International Protection Appeals Tribunal, and last but not least, my colleague and friend, Dr. Janine Silga of DCU. I just want to say how pleased I am that we've such a great lineup of speakers for this event, as well as an all-female panel, and thank you to you all. We will have questions and answers with the panelists at the end. And if you have any questions, you can put them in the chat box, or if you wish, you can send them privately to myself, David, or the Brexit Institute account. So without further ado, I will hand over to David, who I thank again, and I want to thank you all for being here and participating in this event.
Thanks a lot, Niall. I'm very much looking forward to the next hour or so because, as you suggested, it really is a pivotal time with so much happening in the asylum and migration area. Obviously, there's the pending UK Supreme Court decision on the controversial Rwanda Memorandum of Understanding, which we'll hear about in detail. And indeed, this week, there's the similarly controversial plan unveiled by Giorgia Meloni for Italy to use Albania as a hub in a similar way. Other countries in Europe, primarily Germany, but also Slovakia, have had their politics roiled this week by the debate about how to deal with migration. And in the background, of course, there are the complex negotiations aimed at securing a common EU position, which have to conclude by next year when the European Parliament's mandate expires, a prospect that is by no means certain. So much to ponder, and to set the scene for us, we're delighted to have this afternoon Sir Simon Hughes, former Justice and Civil Rights Minister in the Conservative Lib Dem coalition. Sir Simon served as Deputy Leader and President of the Lib Dems before serving as a Minister between 2013 and 2015, when, I might say, after that election, he was succeeded by Dominic Raab, a here today, gone tomorrow politician, I might say, compared to our speaker this afternoon. After all, Simon Hughes served for over 30 years as the MP for Bermondsey, which I hope he won't be upset if I characterise as a gritty East End constituency, which has seen remarkable social changes over the years. And even though he's not still their MP, he's still involved with the area, serving as Chancellor of the South Bank University, and of course, as is de rigueur in that area, continuing his allegiance to Millwall Football Club. Well, it's not quite the Lions' Den here this afternoon, Sir Simon, but you're very welcome nonetheless. And we're very keen to hear your thoughts on the topic in hand.
David, thank you very much. And thank you very much, Federico, for the initial invitation to come. Niall, for your kind welcome and for the opportunity to take part in this event with some very eminent colleagues on the panel who I'm very pleased to meet, even if it's virtually at this stage. But greetings to you both in Dublin, and if you're in Liverpool and wherever else you are. So very pleased to be with you. So this is a very exciting day for me. I'm Welsh by heritage, which is why I'm wearing a Welsh top. I thought at least we Celts who didn't win the World Cup rugby could stand together in solidarity and start the day with the degree of agreement. It's an exciting day because I'm doing this event, and it's a very important and topical event, as you both have said, Niall and David. Secondly, because just about an hour ago, I had an expected delivery of the last book that had been published that remains available to purchase of my Welsh ancestry, which I had ordered through the suppliers. So that's a treat afterwards. And thirdly, the news today in the UK is that the Home Secretary, the now well-known Home Secretary, Suella Braverman, has got into further trouble, not just by writing an article which is critical of the Metropolitan Police in a way that appears to overstep the boundaries between government and devolution of power, but apparently that wasn't even signed off by the Prime Minister and has made very controversial remarks. So there's a great debate going on in the UK yet again as to whether our Home Secretary can be kept in office even though she's undermining the Prime Minister, or whether she may have to lose her job for doing so. And the political turmoil in the UK is a background to this. I'm going to take no more, I hope, than a quarter of an hour, and I'm going to whistle through what is a huge subject with huge amounts of changing parts. And I come to this as a lawyer by training, a Liberal Democrat, a Liberal by politics, an ardent European by philosophy, but not the granular expert these days. I watch these things, if you like, from an informed engagement rather than from an academic perspective. But I'm just going to therefore share the background, and then we'll talk about the key legal issues that are certainly on our agenda in the UK and appear to be replicated in some ways elsewhere in the EU. So, Brexit. The dates first were a series of them, just to remind us. 2016, when the British people by a majority of 52 to 48 voted to leave the EU. 2019, when the Conservative government was elected with a large majority on the manifesto Get Brexit Done, led by Boris Johnson, end of 2019, and in 2020, the two crucial dates when we both formally left and then when the transition period ended. And there are people who've said that the referendum campaign, which was Take Back Control, that was the theme of the Brexiteers, was won for the Brexiteers on migration. That was the key issue, which probably moved as many people to think that if we left the EU, we could control our borders. As you will all know, the paradox is that in terms of numbers, that has absolutely not been the case. Indeed, the opposite has been the case. The next thing is that obviously we have throughout this period been signatories, founder, authors of the European Convention on Human Rights, but there's been an increasing debate in the UK as to whether that is something to which we should continue to adhere, especially if on issues like this, the court intervenes to prevent Parliament, as it's said to be, having its way. Of course, we don't have majority governments under our electoral system. All governments are normally minorities in terms of the popular vote. Then to remind you, we had a series of different Conservative governments since the referendum with different prime ministers. David Cameron at the time stepped down, then Theresa May, then very briefly Liz Truss, or very briefly for 2 years Boris Johnson, and then Liz Truss for 2 minutes, not quite, for 50 days. And then we've had for 1 year Rishi Sunak, and I'll come back to their policies because they've each added a bit to this policy mix. We've had Home Secretaries who've had very strong views on immigration in this time. Theresa May was the Home Secretary, of course, under David Cameron before she became Prime Minister. Then we had Priti Patel. We had Suella Braverman for literally a month. We had a man called Grant Shapps for literally 6 days. And then we had Suella Braverman again for the last 2 years. And one of the themes of that period was that until we had Rishi Sunak, the relations between the UK and the EU post Brexit were very unfriendly, hostile, difficult, and fractured. Mercifully, that has improved to an extent. Across the water from us in a southerly direction, as opposed to in a westerly direction, there have been, of course, key changes of leader elsewhere too. The EU has gone from being Juncker-led to Ursula von der Leyen-led. Merkel has gone and been replaced by an opposition leader from the centre-left, Schulz. Hollande has gone. We might forget that at the time of Brexit, Hollande was the French president, and Macron has come to power and been re-elected. And in Italy, I won't list all the prime ministers because in good Italian form, there have been a lot in a short period of time. But Giorgia Meloni has become the last of those. And in Spain, relevant because they have large numbers of asylum seekers and migrants coming to their country too. We've gone from a conservative right-wing government to a socialist left-wing government. The other things that have happened to the world in that period, and particularly that have motivated things in the UK, the world has dealt with the COVID pandemic, hugely changing migration patterns from 20 to 23, suddenly dropping them hugely before they have picked up again. There was then the crisis in Afghanistan, which has been significant in the UK, where we've had very, very large numbers of people coming from Afghanistan. We've then had the invasion of Ukraine by Russia. For the last year and a half, significant numbers of people coming into many countries in Europe, including us, from Ukraine. And probably just in the last few days, events in the Middle East may produce further people seeking refuge or asylum. Obviously, for those who are lawyers amongst us, we understand that there are differences between asylum and asylum seeking and people who are coming as refugees through international protection or other routes. And there are those probably two broad categorizations of people who've come here. And then in the UK, the governments most recently have legislated, I've got a copy here, just in case you had never seen it, of the Illegal Migration Act 2023, which became law in July, a very, very radical piece of legislation, which we'll come back to in a minute. And then we know, and you've just referred to it, David, in your introduction, we have a case, a live case before our Supreme Court. The hearings have taken place before the President of the Supreme Court and his deputy and 3 other of our Supreme Court justices on what's called the Rwanda solution, which is the proposal of the current government, first formulated and agreed in April last year, so about 18 months old, to be able to offshore our asylum seekers to be dealt with in Rwanda. I'm just going to go back to some of the policies which have come through this period. So Tory policy, Conservative policy from before 2010 was to get net immigration down to the UK to tens of thousands. It had been always over 100,000 since the beginning of the century. Not achieved. By 2015, when David Cameron called the referendum, it was still over 300,000. After we left Brexit, Theresa May put a cap on non-EU skilled migration. She had a policy to close bogus colleges. She wanted to end the abuse of study visas. She wanted to increase the minimum income threshold for family members and break the links between immigration and settlement. And all those things were delivered as part of her policy. Boris Johnson cancelled or got rid of the net migration target and introduced what he called an Australian-style point system. Again, those of you who are very close to this will know it really isn't an Australian-style point system, but that was a helpful generic title. And since then, there have been particular reasons for, under the new system, which is meant to be a tighter system, dealing with both the Afghans and the Ukrainians, and in the UK case, a very large number of people coming from Hong Kong under a special scheme, but also people to deal with our care needs, like care workers. We've given, there's been a control on post-study work visas, having initially expanded it. We've now said people can't bring their dependents. And then under Mr. Sunak, the big policy when migration, illegal migration, or people coming to the UK for asylum moved from being by lorries and trucks, by vehicles, to being by boats, his major policy became stop the boats. A deal has been done with our country with Albania. And if you look at the back of the Illegal Migration Act, you'll see that there are listed in the first schedule the countries which are the so-called safe countries for us. They're all the other EU countries, plus another collection of countries, 57 in total. Some, interestingly, all in Africa, which are said to be safe only for men, countries like Gambia, Ghana, Kenya, Liberia, but not for women. Most of the rest of them in Europe, but a few elsewhere, like Ecuador and Brazil. So there are now some safe countries as well. I want to deal with the Illegal Migration Act first, and then with the Rwanda court case, which is the significant one where we're expecting the decision before the end of the year. So the Illegal Migration Act has changed the law, although it has not entirely come into force yet. Some of it will come into force in the coming months, which effectively says that in future, if you have come here illegally, you cannot have an asylum application dealt with in this country. You will be detained, you will not be admitted, you'll be detained, and you will either be returned to your own country or a safe country. Unaccompanied children under 18 are an exception to that. There is a power under the Act. There's not a duty to detain, but there's a power to detain, which actually, as yet, the Home Secretary hasn't pressed the button to enact. There are return assumptions being valid to each of the other EU countries, plus the 4 EEA countries, Iceland, Liechtenstein, Norway, and Switzerland. There's a provision in the Act to, in future, set a cap on the number of refugees coming into the UK every year, which we've never done before. We've had individual schemes, but there's never been an overall cap. We have a Migration Advisory Council. Many other countries do too, but this would legislate for a cap. And the Home Secretary will have a power to decide, not just in asylum cases, but in all cases, what's the reasonable period for detention of somebody for immigration purposes. There's some consultation still to happen, at least on the migration cap. So we have a new piece of legislation, untried and untested, and then we have the Rwanda case awaiting judgment. This was a case, again, in summary, and we might want to explore this, people will be aware, I expect, where after the deal was signed in April 2022, the deal was that we had done a deal, we paid a significant amount of money to the Rwandan government for them to take the asylum seekers from the UK, who we sent to them. They could then be either given refugee status in Rwanda, or permitted to stay in Rwanda on other grounds, or to seek asylum in another third country. That was the deal. There might have been, the part of the deal is that Rwanda could send people to us as well if they wanted to. It could apply to anybody entering illegally after the beginning of last year, without any limit of number. So no number was fixed. There was then originally a plan to send a plane load of people, initially 47, it came down to 7, but at the very last minute, the application made to firstly the High Court in this country, and then at the last minute to Strasbourg, resulted in Strasbourg ruling just before Christmas, the European Court, in an interim ruling that it was not legal for the decision of the High Court to be upheld, which was to allow people to be sent to Rwanda. Not on the basis that it was illegal to offshore people. That's not a matter that's in dispute, but on the basis that there hadn't been time properly to consider whether Rwanda was a safe place for that to happen. I'm doing this in summary lay terms rather than detailed micro terms, because as you appreciate, we've had High Court judgments. We then had a Court of Appeal judgment, interestingly, with the Lord Chief Justice and the second most senior, the Master of the Rolls, and the third most senior judges in the Court of Appeal, That had a majority judgment that was delivered in the summer, where the Lord Chief Justice was in the minority, and the other two judges, therefore, were the majority. They did not uphold the government's position. They said that they could not be satisfied that Rwanda was a safe country. They could not be satisfied that Rwanda would not send people inappropriately, using refoulement, phrase commonly used in law elsewhere, or that it would not breach both human rights, international human rights obligations, Refugee Convention obligations, or in particular Article 3 of the European Convention on Human Rights Convention, which gives you a protection for your family and your personal rights. And it was on that basis that, by a majority of 2-1, huge long judgment, very worth reading if you haven't done it already. It's 161 pages, but it's a solidly argued judgment. They decided that the government could not go ahead. Government, not surprisingly, appealed to the Supreme Court. There was a 2-day hearing in October. There were appeals and cross appeals. The 10 individuals in question in this case, 9 came by small boats, 1 came by lorries, by a lorry. They came from Syria, 3 of them, and the others from Iran, Iraq, Vietnam, Sudan, and Albania. They came not all directly from the other side of the channel. Some had come by very roundabout routes. But there were also interesting interventions in the court case, because the United Nations High Commission for Refugees intervened, and 2 charities in the UK, Asylum Aid and one other, intervened as well. So the Supreme Court had before it the debate about whether the Home Secretary had, for example, reasonably or unreasonably accepted the assurances given by the Rwandan government, and whether it was sufficient, whether the work done by the UK executive had been sufficient to satisfy itself, and whether the courts at a lower level had had opportunities to be able to assess properly whether human rights could be protected. So we wait that judgment, and it will be a significant judgment, but it will not be the end of that road, because it doesn't mean to say that couldn't be challenged in due course as well. It could potentially be challenged, whatever the outcome of the Supreme Court is, by that case being taken to the European Court. And I would expect, if the 10 people and their representatives lose the case, that is what will happen. So with a general election in the UK bound to happen no later than January 2025, it is not yet certain to anybody that the government would be able to see through its Rwanda wish by then. And it hasn't done deals yet with other countries outside the EU and the EEA countries, other than with Albania. So there aren't any other places where it could deploy that. I just want to end with a couple of other things. I'm sure things will come up in conversation as well. Obviously, I'm conscious that whilst this has been going on, the European Union has been trying to get its act together. Not easy, given the very different views across the EU. There was a majority decision, as I understand it, just this last month in October, agreeing the pact on asylum and migration. I guess it's a fairly desperate attempt by the Commission to try to get heads of government to agree things before the change in the people in the Commission next year, at the end of the term of office of the current Commission. And common policies have therefore, to an extent, been agreed. I just want to flag up then the last 3 things looking forward, putting this in context. The opinion polls suggest there'll be a change of government, that the Conservatives will lose their majority. If that's the case, there are those who say actually that a Labour government doesn't look as if it would be much less tough on migration than the current Conservative government would be. It has said it would cooperate with the European Union on a returns agreement. It would end automatic precluding of assessment of asylum applications here by dealing with the backlog and dealing with them more quickly. It would scrap Rwanda, but it wouldn't allow people in on reduced wages, and therefore it's suggested that they would want to start from a tough position. There are other parties like my party which say the way you should decide who can come for things like work and study should be not done by the Home Office, but by the relevant ministries. And then the very last general point is that this is all against a context in which the UK, in the last year, having claimed, the government having claimed that Get Brexit Done would give us take back control, has seen our net immigration figures go from 100 to 300,000 up to over 600,000. We have ended up with hugely more numbers coming to the UK, not illegally, not as asylum seekers, not as refugees, but the total of people coming to work, coming to study, and so on. And my suggestion to friends on the call is that there may be huge changes in all sorts of the groups that may come. There may not be as many Afghans coming, there may not be as many Ukrainians coming or staying, there may not be as many people in the UK coming from Hong Kong. There may be a net outflow of European Union citizens from the UK. There may not be as many international students coming because there aren't as many who can come here at low student rates. But the projections are still that there will be net migration into the UK Office of National Statistics, probably of about 300,000 by the end of the decade. So there is not suddenly going to be a reduction in migrants overall coming to the UK. There is not likely, therefore, to be a reduction in the population of the UK. But the UK, of course, has not been in the brunt of the storm. It's a big issue in the UK. It's a big drama. But Germany, Italy, Spain, France have taken many more asylum seekers and refugees than we have. And if you compare our proportion relative to our populations or relative to the others, we're absolutely middle ranking and not an outlier. So as Denmark's thinking of outsourcing, Germany's talking about outsourcing, Austria's asking about outsourcing, this is an issue where perhaps people will learn from the UK experience, but perhaps in the end, they'll have to work out their own way of proceeding. I hope that's a helpful introduction, and I look forward to a very interesting and informed discussion. And if we can give ideas to our leaders as to what they should do next, that would be brilliant. Thank you very much, David and Niall.
Simon, thank you so much for such an elegant and comprehensive background briefing on the situation in the UK. I'm really struck by the number of government policies, and you call them U-turns, if you will. It does reflect that immigration and migration is such a hot button issue in the UK. But the zigzagging in policy, it does really call to mind Dominic Cummings' shopping trolley, I'm afraid. Now you gave us the background there, Simon, to the Rwandan court. Supreme Court action, and we'll be hearing more about that from our next speaker, but Mathilde Ventrella, who's a senior lecturer with Liverpool's John Moores University, and she's extensively researched the areas of people smuggling and human trafficking, and she's the author of a number of books and articles. But most recently, she's given evidence to a House of Commons committee on those controversial plans to outsource the processing of illegal immigrants to Rwanda. And that's what she's going to talk about today. The central issue, I suppose, is whether the plan is consistent with the UK's human rights obligations. And as you know, that's been argued before a series of courts. So to give us the background and maybe hint at the possible outcome of these proceedings whenever they finish, Mathilde Ventrella.
Okay, thank you. I don't know if you can see my presentation. Right.
Looks good.
Can you? Okay, that's good. So, so Simon has already focused on the case law on Rwanda, and I will focus more in details about the cases, but I will also explain what are the problems with the two recent acts which have been adopted by the UK government, and I am referring to the Nationality and Borders Act 2022 and the Illegal Migration Act 2023. So, as Simon has already said, on the 14th of April 2022, it was concluded a Migration and Economic Development Partnership between the UK and Rwanda. And this partnership created a mechanism of relocation of asylum seekers whose claims are not being considered by the United Kingdom. And Rwanda should have assessed the asylum claims on the basis of the Refugee Convention and other international human rights convention and commitments. At the same time, the UK adopted, as I said, the Nationality and Borders Act 2022. So basically, what did the UK do? The UK, it was called externalization of migration, in the sense that it gave to the immigration officers the power to detect boats in the high sea and expel the people who were not entitled to asylum in the middle of the sea, and so return to their countries of origin or in other countries considered safe, but not even giving them the possibility, the opportunity to reach the territory, so to reach the territory and to claim for asylum. I have to say that this is a big problem, not only for the majority of people who are asylum seekers, but also for people who are or have been victims of human trafficking or potential victims of human trafficking, because these people will not even given the opportunity to explain what the situation was, because they were automatically, if they did not, they were not considered covered by the Refugee Convention, they were automatically expelled. And at the same time, the UK adopted this migration and economic, this MEDP with Rwanda. Immediately, the ANC submitted a warning by stating that sending asylum seekers to Rwanda would have been contrary to the UK obligation under the 1951 Convention on the Status of Refugees, or the Refugee Convention, because when people reach the UK, I mean, the UK has the obligation to assess their asylum application. Instead, in this way, the UK would have eliminated, as we can say, the obligation to assess the asylum seekers. So what happened was that the High Court, while there was already one flight ready to travel to Rwanda, the High Court, the humanitarian organizations referred to the High Court and they asked to grant an interim relief, as Rwanda was not considered a safe country. But the High Court refused to give this interim relief, and so the humanitarian organization applied to the European Court of Human Rights, and the European Court of Human Rights gave that interim relief and explained that asylum seekers transferred to Rwanda will not have access to fair, efficient procedures for determination of the refugee status. The High Court's rulings was irrational or based on insufficient inquiry and gave rise to serious triable issues. So because we are focusing on Brexit as well, I wonder, now thanks to, it depends on the different views, but the European Court of Human Rights was able to stop, to prevent that asylum seekers were sent to Rwanda, which is not considered a safe country. But already the government has threatened to leave the European Convention on Human Rights. The government has said that they want to step out from the European Convention on Human Rights because they don't want to be prevented from applying their policies, and so, for example, restricting the territory to migrants coming, or better, asylum seekers coming from the sea, for example. But now, thanks to the European Court of Human Rights, this has been stopped. But I wonder, now that the UK is not part of the European Union anymore, and if the UK left the European Convention on Human Rights, how can we make sure, me as a British citizen, which I am, as a British citizen, I wonder, how can we make sure that asylum seekers are not returned in countries where they can suffer inhuman and degrading treatment and torture, And so this is a dilemma which I don't have an answer because at the moment there is this risk. But in the meantime, so the High Court, after the interim relief, the High Court dismissed the challenges against the UK government. So the High Court said basically that there was not a problem to send people to Rwanda because the MEDP provide all the assurances that were required. So there was good faith by the Rwandan government, and therefore assurances would be sufficient to avoid any risk of the breach of Article 3, in particular, of the European Convention on Human Rights. I have to say that the High Court didn't find any problem with the MEDP, also because there is an independent monitoring commission that everybody can access, and this independent monitoring commission will evaluate whether Rwanda is respecting the international requirements, and in particular Article 3 of the European Convention on Human Rights. So this is what the High Court stated, but then the Court of Appeal in 2023 was concerned about the principle of the refoulement. The Court of Appeal stated that the claimants were right. The people cannot be sent to Rwanda because, and then the Court of Appeal took into consideration two important cases, soaring, on the basis of which the European Court of Human Rights has already said that people cannot even, extradition cannot take place if the person in question could suffer torture and inhuman degrading treatment in the country where the person will be sent. And it was taken into consideration also the Ilias case, where the European Court of Human Rights explained the procedural duty of states considering the removal of asylum seekers to third countries without considering the merits of their asylum application. So this is exactly the situation the UK is in. So the UK does not want to assess the asylum applications. The UK is sending people to Rwanda. How can we make sure that the UK still is responsible for the people, for the asylum seekers who try to enter their territory when they are sent to Rwanda? The European Court of Human Rights has said that when a country state removes asylum seekers, they still have the obligation to check that the procedures are respected. And can this be done if people are sent to Rwanda? The European Court of Human Rights reached the conclusion that because there are deficiencies in the asylum system of Rwanda, it's not possible to send asylum seekers there because there would be a breach of Article 3 of the European Convention on Human Rights. And the Court of Appeal gave reasons and stated that historically, as the records presented by the ONG show that Rwanda is not a safe country. Rwanda has not the mechanism and the systems in place are not adequate to host asylum seekers and to evaluate whether they can be granted asylum. So the assurances are not enough. I mean, saying that they have given assurances is not enough, because at the moment the situation is problematic, if we can use this expression, in Rwanda, and therefore there is no evidence which demonstrate that Rwanda will be a safe country where asylum seekers will be treated accordingly to the European Convention on Human Rights and other international requirements. I have to add that in 2003 and 2023, it was adopted, as Simon has already said, the Illegal Migration Act 2023. Even the title of the act, Illegal Migration Act 2023, has negative connotation, because obviously it assumes that all people coming to the UK, for example, the problem was people coming by sea to the UK, they are all illegal migrants. And the Secretary of State has the duty to deport, to expel and deport people. And as a punishment, I have to say, if people try to enter the British territory by boat, so illegally as the Act states, they will not be able to claim asylum. They will not even be able to be protected by the Modern Slavery Act 2015, because they will be considered just illegal. No matter what the situation is, no matter what the country where they come from, they will be considered illegal. So I really hope that at the end of the year, or maybe in January, the Supreme Court will take this into consideration and will put a frame to this policy of the UK, which is against asylum seekers, against migrants. I mean, all illegal, by saying illegal migrants, it means that they are criminals. So we hope that the Supreme Court will be a first step to rethink of the politics on a law on migration in the UK, because as you have said, that Giorgia Meloni, yes, she is copying from Sunak, and she has adopted a similar policy in Italy with Albania. But the difference is that the European Commission is already questioning Giorgia Meloni. Instead, the facts of the Giorgia Meloni has to explain how this policy would be compliance with human rights requirements. Instead, the UK is out from the European Union, and so nobody can question. The UK was part of the asylum, the EU asylum policy, but now the UK is out, and there is not a supranational system which can check whether the policies are respectful of human rights, and yes, of human rights. And as a UK British citizen, this is for me a great concern, especially if this government will be confirmed next year. This means that they will go on with their policies, and there is the real risk that they will step out, they will leave, they will scrap the European Convention on Human Rights, which is now, and other international conventions such as the Refugee Convention, which are now still a break to their inadequate policy to tackle migration and refugee issues. So thank you very much for having listened to me. Thank you.
Mathilde, thank you very much indeed. I think we all know a great deal more now about the various arguments that were put forward in the many cases that have been taken relating to this policy. And as Simon was saying earlier, it won't necessarily be over when the Supreme Court rules next month. I only hope that their lordships get a bit more respect than their counterparts got when under the Johnson administration, when they were dubbed enemies of the people, when they struck down the prorogation of Parliament, if I remember correctly. But let's hope there aren't any lingering tensions between the bench and the executive that might affect this ruling. Our next speaker will be well known to many of you as the chair of the International Protection Appeals Tribunal. Before her appointment, Hilke Becker worked for many years in the immigration and migration areas of law, and I dare say very few of her peers know their way about the Irish system as well as Hilke. She's a board member of the Irish Centre for European Law and works regularly with international bodies like the EU Asylum Agency and the International Association of Refugee and Migration Judges. As we know, negotiations are underway to bring about a common EU approach to migration and asylum, and Hilke will talk to us this afternoon about how any reforms that emerge from any new deal might affect a post-Brexit Ireland. Hilke.
Yeah, thanks very much. So what does this all mean for Ireland is really what I'm going to be looking at very, very briefly in sort of 5 to 7 minutes. So I'll focus very briefly on the impact or potential impact of the Migration Pact on Ireland, and then also Brexit and in the context of the Rwanda deal and current legislation in Ireland. So in relation to the Migration Pact, the first question is, of course, will Ireland participate in it? Ireland, as you will all know, is not automatically bound like other EU member states by the EU migration and asylum measures due to Protocol 21 to the TFEU. It was together with that in that position together with the UK, but post Brexit now it is the only country that has this possibility to opt in, and we have Denmark, of course, which is in a different position yet again. So Ireland is looking at the moment, from what can be seen from the political commentary, at the question whether to opt into the migration package as a whole, and specifically looking at the common procedures for international protection in the European Union, which would include a new type appeal mechanism, which would affect, of course, the tribunal that I'm the head of at the moment, and also introducing border procedures for the first time in Ireland, if Ireland was to decide to opt into this measure. And then, and I think the Taoiseach has certainly spoken about this measure also, the possibility of an Irish opt-in into the regulation on asylum and migration management, which would be effectively sort of a responsibility sharing, also often referred to as burden sharing, between the member states, where a certain cohort of people would be relocated from countries that are under particular pressure at the border, particularly at the southern borders of the EU, or alternatively countries like Ireland being able to pay their way out of that responsibility and or rather meeting their responsibility by way of supporting financially the countries that are under particular pressure. But we don't know yet, will this apply to Ireland? Will Ireland participate or not? Political signs seem to be certainly that there's openness to it. I won't say whether that's good or bad. It's not my role here to comment in that regard. But certainly from the noises from the Department of Justice, Minister for Justice has been that Ireland is looking to play its part in Europe in relation to this area as well. Helen McEntee, in a statement of the Minister for Justice, in a statement in June of this year, said that commenting on the agreement, commented there that she said it posed stronger obligations on the member states to implement mandatory asylum and return border procedures. And border procedures, of course, another big issue and question mark potentially for Ireland, because what about the border? What about the border, the soft border with the north in particular, and how would a border procedure, if Ireland was to opt in, how would that work? But recognizing there in her comment that the border procedure would apply to those who present without documentation, those who come from countries of nationality have low recognition rates in the rest of the EU, so below 20%, and that would be an EU average, which also comes. I think that measure comes with the idea that across the EU there should be convergence in outcomes, that people coming from the same country should expect approximately the same outcomes in whatever EU member state they apply in. There is an obligation then on the member states to have adequate capacity to deal with cases that fall under the border procedure. And that would be, from what I can see from the standpoint that I'm at, a very significant resource issue, a resource demand on the agencies and parts of the Department of Justice that are currently dealing with asylum applications. If this is all under the big if of a possible opt-in. There will be also more simpler, more streamlined system under the Dublin procedure, and Ireland is currently presenting that as a significant step, contributes actively to the negotiations of the measures, and is looking to make, according to the Justice Minister, an informed decision on participation in the future. So with regard to affecting the work that I do, it would one of the measures that would come in if Ireland was to decide to opt in would be an obligation to process an appeal against the return decision and the international protection decision So the asylum decision effectively, where that is taken at the same time, that the appeal must also come to the same court or tribunal. And that would be a new thing for Ireland because currently the International Protection Appeals Tribunal, to those who work in this area, you will know that the tribunal only deals with the question of whether somebody qualifies for international protection, for refugee status or subsidiary protection or not, but does not deal, unlike a similar body would in other EU member states, does not deal with the question of humanitarian leave to remain, permission to remain on humanitarian grounds based on national law. So that would be a big change, and the question would then be: would such a jurisdiction still remain with the tribunal? Would it be, or would it fall elsewhere? The Asylum Procedures Regulation, as it's currently drafted, is, of course, as you would expect, contains a right to an effective remedy in Article 53 of the regulation, which mirrors or certainly seeks to implement the obligation of the member states under the ECHR under Article 13 and also 47 of the Charter of Fundamental Rights. If Ireland was to opt in, the border procedure would also create, of course, pressures on the countries, on the agencies dealing with applications and with appeals. The whole process would have to be done within 12 weeks, including from the application through to the decision on the application, and in case of a refusal, also the appeal would have to be concluded all within the same 12 weeks, which would of course pose a huge logistical challenge for Ireland as it is currently set up. But now focusing briefly on the other aspect that I wanted to speak about, Brexit has already had a major impact on the system as we have it here, in the sense that there was a legislative change firstly to deal with the fact that Ireland and the UK could no longer cooperate under the Dublin procedure in relation to allocation of responsibility for dealing with international protection applications. And instead, Ireland introduced for the first time a measure which you can find in EU law, but Ireland hadn't until then implemented that part, that which is contained in the Asylum Procedures Regulation, that a person arriving in the state from a third country that is in accordance with the legislation as it's set out is safe country for that person. And only one country has been designated as a safe country in that regard, and that is the UK and Northern Ireland. So when somebody arrives in Ireland from the UK and seeking to make an application for international protection, the question is first then, will they be admitted into the process here? And they will not be admitted if they have a sufficient connection with the UK. If in the UK, and this is where the Rwanda deal then potentially comes in as a sort of a positive obligation not to end up with a refoulement situation, or with a pushback situation, where in that other country, in that third country, the person must not be subjected to the death penalty, torture, or other inhuman or degrading treatment or punishment. And then also the obligation is to test whether the person would in fact be in reality admitted back into in this case the UK or Northern Ireland. There's then, the legislation, the International Protection Act, through which this has been implemented, provides specific tests, which I won't go into now for time reasons, a basis for testing such a connection being there, including the presence of family members, etc. So as I said, only the UK has been designated in this regard as safe, and the Minister for Justice was asked in the Oireachtas about such a designation, and the question of will the designation be upheld in the context of the Rwanda deal. And she said that the government policy regarding immigration and international protection matters in the state is kept under regular review, and that there are no current plans to amend the designation of the UK as a safe third country. So that was in July, and while the cases that have already been spoken about were already ongoing. UNHCR, as previous speakers have already mentioned, have termed the designation of the UK as a safe third country, have termed the Rwanda deal as being in breach of both the ECHR and the Refugee Convention. And the question is, and these are questions, certainly currently before the Irish courts, whether the designation of the UK as a safe third country is in violation of Articles 18 or 47 of the Charter of Fundamental Rights. And quoting in those cases, certainly the arguments that are being made is that the UK Nationality and Borders Act undermines established international refugee protection law and practices, and would deter asylum seekers by relegating most refugees to a newer, lesser status, and being under constant threat of removal, and also critiquing the Illegal Migration Act, which has been mentioned, which has been condemned by UNHCR as being at variance with the country's obligations under international human rights and refugee law. And saying clearly that the Rwanda deal is contrary to the prohibitions of refoulement and collective expulsion, rights to due process, rights to family and private life, and the principle potentially also of the best interest of the children. And as you all know, an interim measure has been granted by the Court of Human Rights, quoting again what UNHCR is saying about the situation. So I won't go into the detail. I think that might give you enough of a window, and if there's questions on the situation in Ireland and the impact here, I'm happy to answer them later on after the next speaker. Thank you.
Okay, thanks a lot. That was fascinating. I must say, I hadn't realized that opting in to any pact would present Ireland with the kind of challenges that you outlined, both in terms of resources and indeed in the most sensitive political area of all, how people would be dealt with at the border with the North. Has certainly given us a lot to think about there. Our last speaker is Janine Silka, who's an assistant professor in European Union law here at Dublin City University. Before that, she held postdoctoral positions in the University of Luxembourg and at the Ca' Foscari University in Venice after completing her PhD in law at the European Institute in Florence, where her doctoral research dealt with the legal dimension of the migration development nexus in the EU. This afternoon, she'll speak to us she'll speak to the external dimension of asylum beyond the implications of the Rwanda situation that we were hearing about, and then she'll touch on the situation after the 2015 migration crisis and its causes. Our last speaker, Janine Silka.
Thank you very much for the kind introduction, David. Many thanks to Niall as well for convening this event. Thanks to you, Federico, for providing this platform for our discussion today. And last but not least, thanks to you, Lucrezia, for making sure that everything is going smoothly today. So I'm delighted to be here, absolutely, to be part of such a distinguished panel to discuss this very important and also interesting, fortunately, issue. So as you were just mentioning, David, my presentation will deal with what can be called the external dimension of the EU asylum policy, and especially the increasing move towards extraterritorial asylum policies. And my objective is to highlight, so to take a step back and to highlight how, at least within the EU, this phenomenon has much wider ramification and implication that extends to the whole field of migration and even beyond this field. So the previous speakers have spoken extensively about the 2022 UK-Rwanda Memorandum of Understanding, and while this instrument is a striking example of the direction currently taken by European countries when it comes to their external cooperation on asylum, this is not a unique example. I may say, unfortunately, but this is not a unique example. So in this respect, we can think about the initiative taken by Denmark in 2021 to externalize the processing of asylum claims outside its territory. So some scholars, and I have to mention some Danish scholars, have observed that this initiative, I quote, represents a fundamental shift from the traditional perceptions of territorial asylum, according to which the state where an asylum seeker arrives normally would assume responsibility for not only assessing their asylum claim, and if this person is found to be in need of international protection, that is of asylum, this state would be also responsible for providing such a protection. So to give a bit more context about the Danish situation, which is probably the closest example to the British one in the EU, in June 2021, Denmark passed a legislative amendment allowing for the transfer of asylum seekers to a third country to process their claim for asylum there. The UNHCR at the time had issued some very critical observations on this initiative ahead of the adoption of the amendment, but this was to no avail. So on a side note, Denmark had also entered into a memorandum of understanding on cooperation on migration and asylum issues with Rwanda. So this was also in 2021, but in April of that year. And this memorandum of understanding actually does not concern the transfer of asylum seekers from Denmark to Rwanda, but rather this instrument deals with the strengthening of Rwanda's asylum system and especially Rwanda's status, refugee status determination. So as you can imagine, this memorandum of understanding could be definitely regarding as paving the way for extraterritorial asylum in the future, in a way that is similar to what is happening currently in the UK. So this was actually confirmed in a joint statement on bilateral cooperation in which it was mentioned, I quote, that Rwanda and Denmark are jointly exploring the establishment of a program through which spontaneous asylum seekers arriving in Denmark may be transferred to Rwanda for consideration of their asylum applications and protection there. So there is no major difference between the approach, this approach adopted by Denmark and the one of the UK-Rwanda Memorandum of Understanding. However, and this might be good news, it depends, there have been no concrete actions taken so far by Denmark, unlike what happened in the UK, which remains at least to this day a unique case in Europe. But what about the reaction in other EU member states? So some observers have identified a phenomenon of what they call a contagion between the different member states, as the idea that asylum seekers could be sent to non-EU countries for their claims to be assessed there is actually spreading, and non-European countries, to be more precise. So in a letter of February of this year, so Sir Hughes was mentioning that, at least in part, so in letter of February 2023 was addressed to the President of the European Commission and to the President of the European Council. In this letter, 8 member states voiced their concern about the rise of irregular immigration, and in particular, the fact that, I quote, as long as the European asylum system and its very low rate of returns constitute a pull factor, third country nationals who are not in need of international protection will keep risking their lives on the dangerous journeys towards Europe. So in this letter, these member states also invited the Commission to present a comprehensive European whole-of-route approach that would include legally enabling safe third country arrangements with relevant countries along the EU's external border and beyond. And it was specified in this letter that those arrangements would have to be inspired by the EU-Turkey statement, the famous or infamous 2016 EU-Turkey statement. So even more recently, and I have to thank you, Federico, for this information. On Monday of this week, Italy and Albania have signed a memorandum of understanding, which should allow the transfer of some migrants. We don't really know who they are. Some migrants who have been actually rescued at sea on their way to Italy. So this should allow the transfer of some of these migrants directly to Albania for their detention primarily, and potentially for their asylum claims to be processed there. So this is actually quite unclear. It is still unclear, and it is not clear either whether this instrument will effectively apply in light of its many legal loopholes, but it exists. So for experts in the field of asylum and migration, more broadly, the existence of an external dimension to asylum in the sense of extraterritorial asylum is usually odd at first sight, and this was experienced very powerfully by the second speaker. I think it was you, Matilda, because actually the whole structure of asylum is built on the right not to be expelled to a country where a person, and especially an asylum seeker, might face persecution or inhuman or degrading treatment. And this right, the right to non-refoulement, is mirrored by corresponding obligations for states, and especially for those states that are contracting parties to the 1951 Geneva Convention, to guarantee a right to seek asylum in principle where a person is actually located. So in other words, the pairing of asylum with either cooperation on readmission or on cooperation for the bargaining, so to say, of asylum seekers in exchange of funding does constitute a paradox. So the question is how this external dimension of asylum, which is quite an odd phenomenon, has actually come into existence. So the 2015-2016 crisis is commonly regarded as the turning point, which has led to a dramatic shift of thinking about an external dimension of asylum, so with the adoption of arrangements such as the well-known EU-Turkey statement. And this is what Violeta Moreno Lax has described as the crisification of asylum and migration. But is it really the case? So my main hypothesis is that actually the externalization of asylum, and especially the rise of extraterritorial asylum, has been long in the making. And my hypothesis is especially that the deeper roots of this current movement towards extraterritorial asylum are threefold. So first, it results from putting readmission and return at the heart of the EU migration policy. So there are no consideration for other ways to approach irregular migration, at least at the moment. Second, this shift results from the increasing informalization of the cooperation with third countries in the field of migration. And the final point is to consider is the instrumentalization of EU funding for migration management purposes. So I will now say a few words about these reports, and I will try to be very quick on that. And I will start with readmission. So the readmission of non-EU citizens, who are staying irregularly in the EU territory, has been a policy priority for the EU since the early 1990s. There is nothing new about that. And this was also recently confirmed in the new pact on migration and asylum that was initiated by the European Commission in September 2020. So currently the EU has entered into 18 readmission agreements with different third countries across the world, and the human rights record of some of them is not the best. So in practice, it has not always been easy to enter into readmission agreements because a specific procedure has to be followed. The needs of both partners have to be negotiated, and the human rights guarantees have also to be included within this instrument. And this explains in part why there has been a progressive move towards the adoption of readmission arrangements rather than readmission agreements. And this started especially with the EU-Afghanistan joint way forward adopted in October 2016. Prior to that, there was obviously the famous EU-Turkey statement, but this was not strictly speaking about readmission. That's strictly speaking. So when it comes to asylum, this era of informality, and this is my second point, actually goes back to the global approach to migration and mobility, which was the leading policy strategy that was initiated in the middle of the years 2000. And this global approach led to the adoption of mobility partnerships on different migration-related issues, including asylum at the time. And as they were soft law instruments, they were adopted in the form of political declarations between the EU and different third countries. And this is actually the legal form which has been kept for the current arrangement that we are discussing today. So at first, Informality was perceived as a way of experimenting in the absence of stronger legal basis, or because it was not possible to agree on the content of a readmission agreement, for example. So this is the case of the ongoing discussion between the EU and Morocco, for example. But in the current post-crisis context, this has now become the main way to cooperate with third countries on very difficult migration issues, including asylum, obviously starting with the EU-Turkey statement. So the systematic resort to informality is even more problematic from the constitutional and institutional point of view, because Article 78.2, paragraph G of the TFU actually provides for an explicit legal basis to enter into partnership and to cooperate with third countries on asylum. So this actually has led an observer, so Violeta Moreno-Lax, to mention that this informalization and the cooperation on asylum has led to the progressive debilitation, so here I quote, of the constitutional principles and international conventions that apply in the area. So now, the consequence of putting readmission and return at the center of the EU migration policy, combined with an increasing resort to flexible arrangements, has led to a form, and this might seem exaggerated for some of you, sort of corruption of the external policies of the EU under the so-called comprehensive approach to migration. So this is my third and final point. And a clinical example of it is the EU development policy, whose existence, whose very existence has been put to the test by concurring migration policy objectives. So the main example is the Emergency Trust Fund for Africa that was created in 2015, whose central objective was to tackle the root causes of immigration. And this includes also forced migration. And more recently, this has been confirmed in the Global Europe regulation that created the Neighborhood Development and International Cooperation Instruments. So the submission of EU external funding to migration management objectives has led to a form of conditionality of EU development aid and more broadly of EU external funding, of the delivering of EU external funding upon the willingness of third countries to support EU migration management and in particular readmission. So I think that I will stop for now. I stop here because I think I've spoken far too long and I'm looking forward to the discussion. Many thanks for your attention.
Thanks, Janine. That was great. It does look as if extraterritorial processing is something that, you know, even if it makes people a little nervous, is maybe not here to stay, but here for quite some time. Niall, perhaps you might be able to facilitate a discussion or questions there, can you?
Absolutely. Thanks very much, David, for all the comments. So if anyone has a question that they would like to put to the panel, you can put it in the chat box now. I don't see any for now. So I had a question I wanted to ask the panel that I might just kick things off with. So I was just thinking, I want to pose it as kind of a hypothetical. If an EU member state were to follow the course of the UK with a relocation agreement, such as we've discussed, what criteria should be insisted upon that go beyond satisfying the risk of refoulement? So it seems to me that complying with this merely means that there be an independent judiciary in place in the recipient country, the ability of the judiciary to resist pressure from the authorities, which to me really seems like, you know, a low level, let's say. So what other criteria could be insisted upon by EU lawyers opposing these agreements that go beyond this, if such a scheme were in place? So that was a question I was thinking about through the discussion. So if anyone wants to try and answer that, I'd love to hear your answers.
No one's rising to the bait, Niall. Simon?
I'm happy to have a quick go if you like, Niall. Although there are others who may have a more specific legal. I think the political answer to your legal question is that the other consideration, which is a relevant one in Rwanda, is what the track record is of that country in dealing with these things up to the moment this question is raised. And we didn't get into details, but one of the reasons that Rwanda is controversial whatever the assurance is given, and whatever the belief and acceptance of those assurances by the UK government last year, is that A, it does not have an unblemished track record generally, and B, there's some very specific statistics which show that the reassurances are unlikely to be credible, in spite of the sorts of conversations that we heard earlier that Denmark might have been having to make them more reputable internationally. So the one example is that I'm aware of, that in relation to when they have been looking at refugee or asylum applications from Afghanistan, none of them have been accepted. And I think any country which doesn't accept any applications, I don't have the full set of figures as to whether there have been appeals and so on, but if a country is saying nobody from Afghanistan would have their case accepted, people would begin to be very doubtful, given the very, very, very strong reasons for many people to leave Afghanistan. So I think there's an overarching political question: what is the prehistory of that country up to the moment of consideration? You could obviously, both in any agreement and in any laws passed, set out other preconditions. And you could legislate. We've heard just in the last contribution, which was very wise from Janine, that countries are seeking to enter into memorandums of agreement or enter into non-legislative documents. I mean, obviously they can be questioned in the courts, but they're not. It's not as a result of legislation. You could legislate to put in other preconditions. That would be possible, either by primary or secondary legislation. You could do that. Or you could make sure that you don't do what the UK has done, which I didn't mention, I apologise, that in the latest legislation, the UK has specifically provided that interim measures of the European Court of Justice can be disregarded by our government if it wishes to do so. We've never had legislation saying that before. So you can choose to legislate both in a positive and in a negative way, in a restrictive and an opening way. But it probably ought to be taken in the context also of the track record of the place. But Janine may have a better example of what other legislative thresholds there might be. Janine or Matilda as well.
I'd like to add something else. I mean, if my concern is that if these agreements were allowed in the European Union, I believe they would cause fragmentation, because not an holistic and uniform approach towards migration and asylum. So if Italy has an agreement with Albania and then with another country which is considered safe, then Germany has other agreements. I mean, this would be, for me, from what I understand, the end of the European Union, the European Union integration, and the principle of solidarity. So I'm completely against this at the moment. I'm against this kind of agreements, because they would create fragmentation and not solidarity between EU member states. So we could have other countries leaving the European Union and the failure of the European Union as a whole. So this is my concern. I don't even think that such a question should be asked. We should think that this kind of agreements are possible in the European Union as a whole. This is what I believe. It should be an holistic approach, and otherwise other measures should be taken in order, for example, economic developments in countries outside the European Union, economic cooperation, improving of democracy in countries which are not considered safe, for example, with agreements with the African Union. But I don't believe that the single member states should conclude agreements similar to the one which is trying to conclude the UK with other member states, just to return migrants, to not to want to deal with asylum seekers, refusing to deal with asylum seekers, refusing to deal. Even the meaning of the Refugee Convention would not have any reason to exist, I believe, because the Refugee Convention says that people can escape from their countries, the countries where they can be resettlement, and they can seek asylum abroad. And so this principle would be jeopardized if we allowed and consider having these agreements as a normality, as the new direction that the European Union will follow. This is
now, can I just do one sentence of response? I see their hands up.
Thanks, man.
I think the problem, Matilda, with that argument is that unless I have missed something in terms of the treaties of the European Union, there is nothing that requires the member states to have a common policy on this. So they are currently all free to decide external border matters. Obviously, the internal matters, the Schengen matters are EU policy. But at the moment, there isn't a European Union obligation. And therefore, countries are all free to make their own decisions in their own domestic law. And reading the politics of the EU 27, I very much doubt that you would get an EU-wide agreement that there should be EU policy on this. So I can't see in the foreseeable future anything that would, in law, stop any EU country making its own legislative decisions in the way that outside the EU, the UK has done. But that's my response. I hear Matilda's enthusiasm for a European-wide solution, but in law, I don't think it's in existence.
Thanks very much, Simon. Perhaps we'd hear from Hilke next, and then I see that Hava has her hand up as well. Hilke,
yeah, just very briefly, just in immediate reaction to what Simon was just saying. I was just thinking, one thing though that the EU is not allowed to do, EU member states individually are not allowed to do, is to restrict the right to access to asylum. So that's the question, sort of, where exactly does the land lie between the two? You know, when you're externalizing, yeah, the argument obviously from those states that are implementing those measures at the moment would be that they're not restricting access to asylum, but under the Asylum Procedures Directive and also, of course, under international human rights law, there's an obligation to facilitate access in the sense of allowing people to make an application. And then the big question, which I hope the Supreme Court of the UK will answer, is that restricting access to asylum or not? The moving of people to Rwanda in this case. So obviously the jury is out on this, literally, but just that thought came into my head there in relation to obligations of the EU member states under asylum procedures regulation.
Thanks very much, Hilke. So we'll close shortly, but I see that Hava has a question. So Hava, can you unmute yourself, or is it comment? Lucrezia, can we unmute Hava? I think she may have left the discussion. Janine, you want to make a final comment before we close?
Yes, perhaps on what we've just been saying. So it's true that strictly speaking, extraterritorial asylum is not prohibited. It's not either prohibited in the Geneva Convention itself. But I would say that when it comes to making sure that asylum seekers will be sent to places where they will be able to have their rights in generally speaking, so beyond the fact that they can just claim asylum, respected, the threshold in the EU is very high. So we have to look into the Procedures Directive on the criteria for safe third country. So probably, Hilke, you would have more to say on that. And the threshold is very high. It's not just about the structure, the procedural structure, or the fact that the country has signed this or that agreement. And I would say that from the point of view of international law, broadly speaking, if there would be so within the EU, there are also some ways to make sure that this would be respected. So we have different procedures, the infringement procedures, if a member state would violate those obligations under which they are, also as a matter of EU law. So we would have EU procedures, but there is also the international responsibility of states, which might be also engaged as at the international level. So I don't think it's that simple actually to go against those principles for let's say migration management purposes simply. Thanks.
So I see we've nearly reached time. I see Hava's there. Maybe a last chance, Hava, if you have a comment or a question you want to ask. Okay. So listen, I don't think we have any further questions or comments. So I think we can bring the event to an end. We've been here for an hour and a half. So again, I want to thank our 4 speakers and the chair for their interesting talks and contributions. And I want to thank you all for being with us and participating. So goodbye for now. I hope to see you at a future Brexit Institute event. And thanks very much.
Thanks for the invitation.
Thank you very much.
Thanks, Greg.
Thanks.